mañana aquí para inaugurar este ciclo de conferencias que hemos denominado Sesgos Cognitivos y Esferas de Injusticia. Antes que nada, y también sobre todo para dar aquí la bienvenida al doctor Jeffrey Rachlinski, quien nos honra con su presencia y también, digamos, con las investigaciones que ha estado haciendo en los últimos años. Antes que nada, quisiera agradecer el apoyo del doctor Luis de la Barreda, coordinador del Programa Universitario de Derechos Humanos, del doctor Ken Oyama, secretario de la Secretaría de Desarrollo Institucional, el doctor Alberto Vital Díaz, coordinador de la Coordinación de Humanidades, así como nuestro anfitrión, el doctor Pedro Salazar, el director del Instituto de Investigaciones Jurídicas, quien han apoyado e impulsado este evento. Este ciclo de conferencias da continuidad a los trabajos realizados en noviembre del año pasado en el marco del primer coloquio sobre discriminación, sesgos cognitivos y derechos humanos, el cual reunió a más de 40 exponentes nacionales e internacionales para entender cómo los sesgos cognitivos tienen una correlación con actos discriminatorios y violaciones a los derechos humanos. Los resultados de este coloquio próximamente se podrán consultar en una publicación que haremos extensiva al público interesado. Así también es importante comentar que estos temas ya son parte de una nueva área de investigación en nuestra universidad que buscará generar investigaciones experimentales en torno a la cognición social y la discriminación en nuestro país. Los sesgos cognitivos, para aquellos que tal vez no estén tan familiarizados con este término, son puentes heurísticos, es decir, formas de indagación no sistemáticas que utiliza la mente para procesar información de manera rápida, intuitiva y automática. Los sesgos se construyen a partir de unidades cognitivas asociadas con la memoria emocional de las diversas experiencias que tenemos, así como elementos lingüísticos, biológicos y socioculturales que las personas vamos incorporando en nuestra experiencia de vida desde el nacimiento. Estos sesgos hoy en día, y gracias a los trabajos realizados por profesores como Kahneman, Tversky en la década de los 70 y muchos otros posteriormente, sabemos que se alojan en la parte primigenia del cerebro que comúnmente se ha denominado como sistema 1. El sistema 1, a diferencia del sistema 2, que es donde el cerebro lleva a cabo los procesos de pensamientos racionales y reflexivos, ha tenido gran importancia en la sobrevivencia de los seres humanos para actuar ante el peligro. No obstante, los sesgos cognitivos automáticos, o llamados también implícitos, ante condiciones diversas que los refuercen, son la antesala de acciones y juicios que excluyen y generan estereotipos, desigualdad y, como lo veremos el día de hoy, incluso actos de injusticia. Este ciclo toma su nombre en homenaje al trabajo del filósofo norteamericano Michael Walzer, quien en 1983 publicó una de sus obras más discutidas, Esferas de Injusticia. En esta obra, Walzer propone un modelo de justicia distributiva a partir de identificar bienes sociales estratégicos e históricamente determinados, cuya trascendencia social requiere definir mecanismos de acceso y distribución. La justicia, como esfera, es un bien esencial sin el cual las sociedades pueden verse inmersas en procesos tiránicos o totalitarios que sometan la libertad de las personas y la política, entendida esta como el espacio de diálogo y entendimiento de las contradicciones sociales, a la voluntad de algunos cuantos. Por ello, todas las sociedades actuales que presumen ser democráticas aspiran a la justicia. Sin embargo, nuestra experiencia cotidiana en un país como México nos enfrenta a una realidad donde la justicia, en la mayoría de los casos, es inalcanzable. Nos parece más una virtud platónica que una experiencia institucional concreta que permita una sociedad justa y equitativa. En este ciclo de conferencias buscamos explorar el papel que juegan los sesgos cognitivos, estos procesos automáticos y a veces poco deliberativos, en las decisiones y la ingeniería institucional, que en vez de lograr una sociedad menos excluyente, pareciera asegurar que se mantengan las diferencias entre grupos. El sistema legal y judicial es, en teoría, el reflejo de las reglas y normas que una sociedad elabora y acuerda para avanzar el bien público, reconocer y discernir responsabilidades, resolver conflictos de interés y distribuir recursos de forma justa y proporcional. Pero, ¿qué sucede cuando las personas que se les otorga la responsabilidad de hacer justicia no responden de forma congruente con las leyes y con las expectativas sociales de un orden justo? ¿Existen elementos inconscientes y automáticos que puedan estar guiando la actuación de las personas encargadas de hacer justicia? Acciones que reproducen prejuicios y estereotipos de los cuales no necesariamente están conscientes. Una funcionaria de la Suprema Corte de Justicia, hace un par de meses, en un foro en este mismo instituto, comentaba las decisiones de algunos magistrados en torno a la consulta pública y los recursos de amparo de comunidades indígenas que defienden sus territorios ancestrales ante los megaproyectos. No acababa de sorprenderse que incluso cuando el derecho claramente se inclina en favor de los derechos de los pueblos indígenas, los magistrados deciden y justifican su decisión en contra. Para reflexionar en torno a estas decisiones, que puedan estar reflejando sesgos discriminatorios diversos, hemos invitado al profesor Rachlinski a abrir nuestro ciclo de conferencias con un tema que hasta ahora no ha sido trabajado en México y que nos parece de vital importancia. El profesor Rachlinski ha estudiado y documentado en los últimos años la presencia de sesgos cognitivos en actores clave del sistema judicial de Estados Unidos y de los Países Bajos, entre otros. Sus conclusiones arrojan una clara presencia de sesgos que ponen en entredicho la idea de imparcialidad de la Procuración de Justicia. El trabajo del profesor Rachlinski es una ventana a cómo jueces y abogados, en muchas ocasiones, son víctimas de sus prejuicios sociales y raciales respecto a personas que pertenecen a minorías y que han sido sistemática e históricamente excluidas y estereotipadas. Las investigaciones del profesor Rachlinski son una invitación a todas aquellas personas que nos interesa disminuir la discriminación y la desigualdad en este país, a impulsar la investigación aplicada para entender sus orígenes también desde los aspectos cognitivos. El profesor Jeffrey Rachlinski es profesor en leyes de la cátedra Henry Allen Mark en la Universidad de Cornell. Es considerado un innovador en las áreas de derecho administrativo, psicología social y legal. Desde que se integró a la Facultad de Derecho en la Universidad de Cornell en 1994, el profesor Rachlinski ha contribuido con nuevas perspectivas sobre la intervención de la psicología humana en la toma de decisiones de los tribunales jurisdiccionales, agencias administrativas y comunidades reguladas. La visión analítica del profesor Rachlinski lo ha llevado a explorar diversos temas en la práctica legal, tales como estrategias de litigación, daños punitivos, derecho administrativo, derecho ambiental y responsabilidad de daños y prejuicios por productos defectuosos. El profesor Rachlinski enseña psicología social y cognitiva, enfocada a grupos de abogados, derecho administrativo, derecho ambiental, procesal, civil y penal. Tiene estudios de licenciatura y maestría en psicología en la Universidad Johns Hopkins, estudios de posgrado y doctorado en Derecho y Psicología por la Universidad de Stanford. Démosle, por favor, un aplauso de bienvenida al Dr. Rachlinski. Please.
Well, gracias. Thank you for the kind invitation to come to Mexico City and to present to all of you, and thanks to all of you for attending today and allowing me to present my research. When I went to graduate school, I began to study judgment and decision making, how people make decisions. And I began to study that partly because people find that very difficult. People don't like to make important decisions. They tend to procrastinate and put decisions off or try to avoid making difficult decisions. And it's a strange thing to me that judges have decided for their careers to do nothing but make decisions. Judges make very important decisions for people, and for me, judges are among the most important decision makers in the legal system. In my country, in the academic circles in which I travel, most people like to write about our United States Supreme Court. There's many, many articles about the Supreme Court, but for me, the Supreme Court is not the most important court. The ordinary decisions made by everyday judges affect the lives of millions of people in my country, and it's true in every country, that trial judges make critical decisions about people's lives. They've chosen to do that as a profession. They've chosen to do that even though it's very difficult, even though most people would not like to do this for a living. And we as a society, our society in the United States and yours as well, we really count on judges to make unbiased, accurate, reasonable decisions about ordinary people who appear in front of them. And when they don't, it distorts our system of justice. And one of the things I've learned in graduate school, and that is a prime lesson of psychology and decision making, is that people do in fact make systematic errors in judgment. It's very difficult to make unbiased decisions. Our brains seem in fact hardwired to make certain kinds of systematic errors. On the whole, we're lucky in the United States. Our judges are very good, but what I've shown in my research that I'll tell you about today is that judges are prone to make systematic errors as well. I have no idea how to advance the slides. Okay, we're going to do it that way. I'll just signal to you when we're good. Yeah, there you go. So my basic thesis today, based on the work I've done, is that judges commonly rely on intuition to make decisions. You have to keep clicking. These intuitions are surprisingly accurate, but they're also a source of systematic errors in judgment. And good judgment for judges, and for really everyone, for most adults, requires a sort of stopping and thinking. It requires a deliberative mechanism. It requires that judges understand that they have intuitions that might lead to erroneous decisions, but that they take a moment and stop and deliberate carefully before implementing their decision. Now, this thesis basically arises, as I said, from much of the research that psychologists done on judgment and decision making over the last 20 years. Oh, it's going to work. All right, good. It's much easier. Good. So what psychologists have found about human judgment is that people make decisions in really two distinct ways, relying on what sometimes get called two distinct systems. Psychologists refer to one of these two systems somewhat inelegantly as System 1. System 1 is a sort of primitive way of making decisions. It relies on intuition, relies on emotion or affect, relies on association or what things sound like. And importantly for judges, System 1 produces rapid, confident decisions. People who rely on System 1, on intuition, are very sure that they're right. In the United States, tragically at the moment, we have a president who is being called the System 1 president. It's all intuition all the time, and he's sure that he's right. And it's very appealing for many people to have this sort of confident way of making decisions. But, of course, we didn't develop a complicated system of laws with System 1. Human beings, of course, have a second, more careful way of making decisions, System 2. Again, it's not very elegant, but System 2 is deliberative. It involves the reliance on rule-based decision-making, on calculation, on mathematics. It relies on deductive logic. And importantly for our purposes, it's slow. It's effortful. It takes work to rely on System 2. And interestingly, people who use System 2 to make decisions, in fact, are less certain that they're right than people who use System 1. Right? So the use of higher order thinking, it takes a lot of work, and it leads to a little bit less confidence in one's decision making. Okay? So that's the basic lesson of psychology of judgment decision making. And you can find this lesson documented in a couple of two very good books on the subject. One by, of course, the Nobel Prize winner Daniel Kahneman, Thinking Fast and Slow. Fast, of course, being the System 1, slow being System 2. There's also an older book by Malcolm Gladwell, who's not a psychologist himself, but is a very good consumer of psychology, called Blink, in which he talks about how good System 1 actually is. And that's true, in fact. System 1 is a pretty good way of making judgments. You're not going to get far in life without System 1. The problem is that it can lead to error, and it has that overconfidence in it. So generally speaking, among experts and ordinary people making decisions, you really need System 1 and System 2. You can't get by without a System 1. I've spent one day in your beautiful city so far, and I have noticed that traffic is very much like it is in New York City. And if you're going to cross a street in Mexico City or New York City, you need System 1. If a bus is coming at you, do not stop, deliberate, calculate. You will get run over. You need System 1. It will tell you to get out of the way. System 1 will keep you alive. We need System 1. You can't do without it in decision making. The problem is that System 1 is fast, it's effortless, and it's overconfident. So it's that decision gets into one's brain quickly and efficiently without us even knowing it in many cases, and then that seems to guide much of the rest of our decision making. That's perfectly fine if you're navigating the streets of a busy city, and it's probably not so fine if you're a judge presiding over a complex decision involving the lives of very ordinary people. So knowing when to suppress that intuitive judgment, knowing when it's wrong, is really the key to sound judgment. Judges are going to have intuitions about how to decide cases. They're going to have reactions to the people who appear in front of them, many of them positive, many of them negative, many of them for bad reasons. Knowing when that intuition is correct and they should rely on it, and when it's wrong and it's leading them astray, leading them to a biased decision, that's the key to sound judgment. And it's the principal lesson that I have given to judges over the last decade or more. So I'll describe my research program a little bit more here. Along with a number of collaborators in the United States and other countries, many of whom are judges, what I like to do is I go to judges. I have data on over 5,000 trial judges, sitting trial judges. I get them typically when they're at judicial education conferences. Surveying judges is very challenging. They don't like being surveyed very much on the whole. There are exceptions, but by and large, if you send surveys to judges, they throw them out. But if you get them at judicial education conferences, at a moment of self-reflection, they're willing to open up a little bit and participate in research. And I've been very successful at getting judges to participate in our research. What we do with these judges at these conferences is we give them hypothetical questions. We give them hypothetical cases, often involving real statutes and real litigants and the like, but we'll typically vary one thing or another, such that half the judges in our room will see one version of a case and half will see another, often with a very subtle difference between the two that is meant to trigger a particular error in judgment, to trigger a System 1 reaction that will lead judges astray. So what we're looking for is to see whether the same kinds of cognitive errors that we see in ordinary adults also can be found in judges in situations in which they are experts and you would expect they would do a little better. We do find, generally speaking, that the judges are prone to the same kinds of System 1 errors as ordinary adults. They are, however, sometimes much better, as we'll sort of see. I too tend to focus on the errors, though. It's a little more fun. All right, so let me give you an example of one of the questions we asked judges. It's not a legal question, but in fact is one that we've given to thousands of judges in the United States and in Canada. This is the Spanish version. I'll have to read it in English. It sounds like a silly question to ask judges, I admit, but it does reveal something about System 1 and System 2. So the question, I'll give the English version. This is the Spanish. A bat and a ball together cost $1.10. The bat costs $1 more than the ball. How much does the ball cost? Now, when most well-educated adults see this question, they say 10 cents. Bat and a ball together cost $1.10. The bat's $1 more than the ball. How much does the ball cost? $1.10, 10 cents. That pops into people's heads. And if you think the answer is 10 cents, then I'm not really worried that you're going to get run over by a bus in Mexico City today, but it's the wrong answer. 5 cents is actually the right answer. And again, most well-educated adults will say 10 cents, but it's the wrong answer. And here's why. So look, if the ball cost 10 cents, the problem says the bat cost $1 more than the ball. And so that means the bat would cost $1.10, and together they would add up to $1.20. And that's not what the problem says. The problem says they add up to $1.10. So if the ball costs 5 cents, the bat costs $1.05, then that adds up to $1.10, and that satisfies the problem. The problem is not difficult, but it requires that you suppress that 10 cents that pops into most people's heads, do a tiny little bit of algebra, which isn't really that difficult, and then come up with 5 cents as the right answer. But again, most well-educated adults get this problem wrong. And interestingly, if you pay people to get the problem right, if you give them some reward for getting the problem correct, they're actually more likely to get it wrong. Why? And that's the power of the intuitive system. It's an overconfident system of reasoning. You read this problem, it sounds like 10 cents is the right answer. So if there's money on the line, you better go with what sounds right, 10 cents. Interestingly, there was a version of this study done at Yale University a few years ago, where they gave Yale University undergraduates a $5 reward for getting the problem right, and they put one thing on the bottom of the problem. They added one line to it. Here it is. Hint, the correct answer is 5 cents. A quarter of Yale undergraduates still got it wrong. Right? They still said 10 cents. They figured it was some kind of trick. It was designed to get them to lose $5, and so it must be 10 cents. You know these psychologists are always trying to cheat you, so 10 cents must be the right answer. It's really remarkable. That's the power of the intuitive system. It's overconfident. That 10 cents feels right, and so people say 10 cents is the right answer. Okay. Now, we've given this problem to, as I said, thousands of judges, and it's part of a series of problems we've given to judges that are obviously not about the legal system directly, but together they make up what psychologists call the cognitive reflection test. So any three of problems of this sort that have an intuitive response that's incorrect, that people have to suppress, that makes up this particular test and what the test does is it assesses people's willingness to suppress their intuition, their willingness to second guess themselves a little bit, to see how cautious they are about their intuition. And people vary a lot about this. As I said, most well-educated adults will get this problem wrong, but some will get it right. And in those individuals, we know they have a more greater tendency to be willing to suppress their overconfidence and do a little bit of math and get the problem right. And there are people who are very good at this. There are certain types of individuals, partly by proclivity, what they like, and partly by training, who are just better at the cognitive reflection test than others. Engineering students do very well. By the way, that's a very good thing. You do not want to hire a civil or mechanical engineer who relies largely on intuition when they look at the design for a building or a bridge and think, yeah, that looks right. It'll hold up. That is not going to make for a good civil engineer. You want people who stop and do the math, who by proclivity and by training know to second guess themselves, do a little math, and make sure they've got it right. Most lawyers, however, get the question wrong. And we wondered about judges. Are judges more like civil engineers, or are they more like ordinary adults, including like most lawyers? Judges, of course, like engineers, face complicated decisions where they have a complicated set of rules about which they are supposed to stop and think carefully. So we thought that perhaps, maybe by proclivity, maybe they just happen to like rules, or by training or experience, that judges are maybe more like engineers than they are like ordinary adults. However, most judges get the question wrong too. They are like more ordinary adults. Here's a graph of who does well and who does not do well on the cognitive reflection test on questions like that bat and ball question. So undergraduates at the Massachusetts Institute of Technology are very good at this problem. They're not a lot of fun at parties, but they are very good at this kind of a problem. 80%, they'll get 80% of these problems right. It's interesting, though, they should get all of them right. In fact, that there is still a power of intuition among serious high-end science and engineering students that causes them to want to go with their instinct as well. But they do pretty well. Undergraduates at Harvard, it's sort of 50-50. They get about half of these kinds of questions right. Harvard students are very smart, of course, but they include a lot of very System 1 oriented people. Art history majors, philosophy majors tend to, oddly enough, to be more System 1 types. This is European undergraduates. This is a Polish institution that did the CRT. Also, still very good. This is a fine university. You still see a lot of System 1 thinking. This is where judges fit. This is a group of judges from the state of Florida. They like this result, by the way. They're not quite as good at Harvard, but they're close. And so they get most of the questions wrong. They tend to rely on their intuition more often than their deliberation. Lawyers are actually a little better than judges, quite the sort of opposite of what we might have thought. And now the one group of judges we have found to be quite good at this, they're not, this is arbitrators, these are professional arbitrators, are Dutch judges. Judges in the Netherlands are not quite MIT undergraduates, but they're close. Now, the Dutch judges are much more highly trained, oddly enough, than American judges. They tend to start out as judges as a career, and they work in a continental system of jurisprudence more so than the common law country like the United States. And so they have more rules to follow, in a sense. They are more apt to be more deliberative thinkers than American judges. It's really the one group of judges we have who are a lot like engineers. Most judges are intuitive thinkers by and large. But of course, what judges say about this is, well, you know, I don't decide the price of bats and balls in my courtroom. I decide about people. What about judging people? And of course, most of our research really is about people and about legal problems. Some of them involve numbers, like the ones I'm about to tell you about, but everything else we do really does involve a question about the legal system, about law. And so what we do, as I said, is we try to find examples of System 1 processes that one commonly observes in ordinary adults that lead to error, and we see if they translate into judges. One of the System 1 sources of error that we have studied fairly extensively in judges is something called anchoring, sometimes called anchoring and adjusting. What anchoring is the tendency to rely on a numeric reference point when making a numeric judgment. And the interesting thing about anchors is that relying on a numeric reference point when making a numeric judgment is not bad. It's a pretty good way of thinking about the world and can often lead to good judgment, but can often lead people astray. So here's an example of how it leads people astray. This was a study done, oddly enough, at the Massachusetts Institute of Technology, at the business school, though. Maybe a few more System 1 thinkers there. What this professor did at MIT is he auctioned off a bottle of wine to his students. Now, these are MBA students at the Massachusetts Institute of Technology. They're pretty smart. They're about to be very wealthy. This is about just before they graduate, so they can afford an expensive bottle of wine. And what the researcher did is he said, I want to hold an auction. And he described the wine. It's a Côte d'Aron Jubilee. This is a little dated. Now it's gotten more expensive because it's older. It's got 86 points from Wine Spectator, whatever that means. Here's a description of it. It's medium-bodied, medium intensity, nicely balanced, fruity, red berry. Sounds great. Maybe not at 11 o'clock in the morning, but it's a nice bottle of wine. And he means to auction this off. What he tells the undergraduates is, before we start the auction, I want you to do something. I want you to write down the last 2 digits of your telephone number. And then put a $sign in front of that. And then, is your reservation price for this wine higher or lower than that number? Just answer that question for yourself. And then determine what you think of as a reservation price. Because it's a business school. They're trying to teach them something about auctions. And the reservation price is supposed to be the most you're willing to pay for this bottle of wine in the auction, right? But they've used as a numeric reference point a transparently arbitrary number, the last 2 digits of their phone number. The students know that those 2 digits of their phone number have nothing to do with the fruity taste of the wine or how much they're going to enjoy it. Right? It shouldn't affect their reservation price, whether the last 2 digits are 15 or 92. Should not matter. But it does. When they then hold the auction, the winners of the auction, the high bidders, tended to be people who had 9 as the second last digit in their number, rather than everybody else. So in other words, if they had a high numeric anchor as a starting point for the reservation price, they tended to bid much more. And this researcher has run this auction over and over and over again and gets the same result every year. The reservation prices are higher when they start them off with a higher reservation price anchor, even though the students know that it's an arbitrary number. So it leads them to be willing to spend more when you start out as an arbitrary number. And business students get that message pretty quickly. It means ask for a lot when you're asking for something, right? Start people off at a very high number if you're selling something. Start them at a low number if you're buying something. So it's a clear lesson for business school students. Anchoring is a very potent phenomenon, and we have discovered that in judges, it has a very powerful effect on their judgment as well. We've run a number of different studies on the power of random anchors in judges, and I'll just give you a flavor for 2 of the ones we've run. We gave judges, this is a group of judges in New York State, we gave them a description of a problem involving wrongful discharge, wrongfully being fired for this plaintiff. They read a fact pattern that's about a full page long. I think it's 400 words long. The story we tell them, and they know it's a hypothetical, but it's got a lot of legal facts in it that should allow them to decide the case. It's a story about an employer who's clearly liable for wrongfully firing this employee. The employee is, it turns out, is a secretary, and she's a terrific secretary. She has great evaluations, she works very hard, she's very efficient, but she gets a new supervisor who begins using racial epithets to her at work. She's described in the materials actually as a Mexican American, and her employer begins making fun of her at work, including ridiculing her ancestry in front of one of her daughters. And when she complains to her supervisor, he fires her. And then she files a lawsuit. The company fires the supervisor later and admits they were wrong. So they're obviously liable for this. This is a wrongful discharge. The problem is, for our victim here, our plaintiff, is that she found another position immediately. Of course she did. She's an excellent secretary. And in the United States, in a wrongful discharge case, most of the damages are typically lost wages. If she replaced her job with another better position with a better supervisor right away, she has very little in the way of damages. But under the statute she was proceeding under, she's allowed to collect damages for mental anguish. So in other words, if the supervisor ridiculed her ancestry in front of other people and fired her over it, she is allowed some amount of money for mental anguish. See, now this is an area where we really find System 1 has a lot of power. Determining a dollar amount for mental anguish is a difficult task. It's not at all obvious what's an appropriate amount of compensation for having one's ancestry ridiculed at work, in one case in front of one's child. Something, but I don't know how much. So it's a hard thing for judges to do, and they're apt to rely on their intuition. It's also an area where judges have a lot of discretion, where they're not going to get overturned. And so what they decide is going to be what the answer is. And so that's the kind of area where we have found in our research that judges really rely very heavily on System 1, that they rely on their intuition and they don't tend to check it. So it's a good area for us to study. Now, what did we vary? So we varied one thing. So there are 2 versions of this questionnaire. For half of the judges, they read the following, that the plaintiff, while she is testifying, asserts that she recently saw a case similar to hers on a court television show, which are very popular in the United States. I don't know about Mexico, but we have lots of them. She saw a case like hers on a court television show, and a plaintiff received a compensatory damage award for mental anguish. Now, that's very irrelevant testimony. in fact. It tells us nothing about how damaged she was, how painful it was, how much compensation should be appropriate. But, irrelevant testimony is common enough in the courtroom. For half of the judges, they just read that. For the other half, they read the same sentence, but we put a dollar amount in there. So instead of just saying she saw someone be awarded an amount for compensatory damages, she saw someone on a court television show be awarded $415,300 in compensatory damages. Now, of course, we don't know anything about this television show, whether it's real or fictitious, or why it might be relevant to her case at all. In fact, we gave that version of the problem to a group of appellate judges and asked them whether that testimony was admissible. Unanimously, they found, no, it's not admissible. It's not testimony that should have been part of the proceeding, because who knows what television show it was or why it's relevant or why she's even saying this. It's not relevant testimony. We also asked those judges if the testimony had been admitted, would it have been harmless error? Would it have had an effect? And something like 90% of them, 9 out of 10 judges, said it was harmless to admit such testimony. It could not affect judges. All right? But we know whether it affected judges, because we ran the study in which half the judges saw that number and half the judges didn't. And here's what happened. When the judges did not see a number, they just have this testimony that she said, I saw someone on TV get an award. The median award, that is to say half the awards were higher and half were lower than this amount, was $8,000. Right? It seems like a reasonable award for the amount of suffering she engaged in. Half were higher than that and half were lower, but that's a reasonable award. When they heard that she had watched television and saw someone win $415,300, now $50,000 was the right award. It was 6 times as high. In fact, there's almost no overlap in the distribution of awards in the two conditions. That is to say, the highest award where they didn't see the number is actually only a little bit higher than the lowest award among the judges who saw that $415,000. Now that's a System 1 influence. The judges see that very large number, and now $8,000 doesn't seem like enough. So $50,000 comes to seem like enough, or $200,000, or $150,000. So that big number makes a small award seem inappropriate, makes it feel wrong, feel like it's inadequate. And that's very much a System 1 influence on judges. And we've seen this in many different contexts with anchors. So this is a group of international arbitrators. We had some data on these individuals. These are arbitrators from, I think, 50 different countries with a median of 20 years of experience. These are highly experienced international arbitrators at one of the annual conferences. We gave them a fact pattern involving a case involving 2 countries. One law firm had brought a case against another country, and the country had adopted legislation that precluded the practice of law by foreign lawyers. That was contradicted a treaty obligation of that host country, and so the foreign law firm had brought an arbitration, we said, against them for damages. They were clearly entitled to some award. We gave them a long description of what an award might be, and that was the only issue in the case. What was an appropriate award for damages? Okay, and so they had a lot of facts. I won't go through them, but they had a lot of facts as to what was an appropriate award. And we varied one thing. We had 3 different versions of this one. We tell the judges, the arbitrators rather, we tell them at the end, after the final hearing, you go out to dinner with your co-arbitrators to relax. During dinner, as an aside, one of your co-arbitrators mentions a completely different case in which the United States District Court applied a domestic tort law to hold Sudan liable for, and we varied the amount, for injuries resulting from the bombing of a ship in Yemen. Okay. In other words, at dinner you discuss a completely irrelevant case. It has nothing to do with the award in the case in which you're presiding. And we varied the number for the damage award. It's either $1 million, $50 million, or $300 million. And then we asked them to identify an award. So the next day you're supposed to decide on the award. When they read about this case in Sudan that had a relatively low anchor, the median award was $5 million. When they read about a somewhat higher anchor, it was a little bit higher. And when they read about a $300 million award, now that $5 million award didn't seem like enough. And so the award, again, went up to $15 million. So arbitrators, even though they know that that's irrelevant, it's not even related to the case, not even plausibly, it still triggers that system one reaction that first number seems too low, that it looks wrong to them, that it looks like it's an inappropriate award. Okay. That's anchoring. We have found that again and again. That's a very erratic source of decision making. Lawyers love this result. When I give this to talk to lawyers in the United States, they write that down, like ask for more money from judges. And I can't argue with them. The data look like that's really going to work. Now, one other influence we've studied in judges in the United States is something called framing. Framing is the tendency to treat gains and losses differently. Gains, improvements from the status quo, tend to trigger different intuitive reactions than losses. In particular, people are more focused on losses. Losing hurts more than winning feels good. Right? So choices are really evaluated relative to a salient reference point. It's a little bit like anchoring, but there's almost always a reference point in one's choices, and improvements from position are treated one way. In fact, there's a fair amount of neurobiology to suggest that gains just look different and are processed differently at a neurological level than losses are. And let me give you an example. Gains look different than losses, but I think it's best done with an example. Unfortunately, this is a U.S. example, but suppose you bet a friend $50 that Los Angeles and New England played in our what we call football in the United States. They played in the Super Bowl a few months ago. And suppose you bet a friend $50 that Los Angeles would win the 2019 Super Bowl. New England won, Los Angeles lost, and you have to pay out on your bet. How would you describe the outcome? Most people would say if they lost a $50 bet to a friend, they lost $50. It's not complicated. What's the trick? Well, that's accurate enough as far as it goes, but it's incomplete. You didn't just lose $50 if you lost your bet. You failed to win $50 as well. The economic difference in your outcome from winning and losing this bet is really $100, because if you had won the bet, your friend would have paid you $50. So you would have been $50 better off. Instead, you're $50 worse off. But what people focus on, what the mind tends to really focus its attention on, is the $50 loss. The loss hurts. The lack of a gain hurts too, but not nearly so much as the loss. So losses hurt more than gains feel good. And that's another thing we've studied fairly extensively in judges. Do they then focus on losses relative to gains? Is it something that really motivates them and moves their decision making, maybe more than it should? And so I'll give you an example of something we've found in judges. This is a group of judges. They treat losses as more aversive than foregone gains, and they react differently. So here's an example in judges. We gave judges, this is a group of Florida judges, a case involving employment discrimination. Okay, and so what we told them a story about was a 61-year-old plaintiff who had alleged age discrimination. His complaint was that he was treated differently because he's an older employee than some of his younger colleagues. Okay, and his story was he has to demonstrate to be successful. He has to demonstrate that age was, quote, a substantial motivating factor in his employer's decision. If he can demonstrate that, he's going to get past a preliminary hearing stage that this case is at, and then he'll proceed on to be able to prove his case at trial. But if he can't demonstrate that age was a substantially motivating factor, then the case should be dismissed. Okay, so we give the judges some evidence about whether age was a substantially motivating factor in his employer's decision. His employer is a fictitious university called Gatorville College in Florida. And the employer basically had four different people who are up for a particular position. All three of them were under 30, and the fourth one is our victim here, our plaintiff, who's 61. He's much older than the other people who are involved in this, are up for this position. And in the notes that the employer's supervisor takes, he expresses concern about our plaintiff's energy, suggesting that's a euphemism for age, and wonders whether he can understand today's college students. I can't understand today's college students, so I kind of sympathize with them. But that's going to be evidence of age discrimination, but inconclusive evidence. So the question for us is how the judge views this somewhat inconclusive evidence. Does it show that age is a substantial motivating factor or not? And again, we varied one thing. For half of the judges, what we told them was that 4 people had applied for 3 positions. These were 4 finalists for 3 different positions. 1 are older individual, and the other 3 are younger people. And so the university hired these 3 younger people. So his claim is he wasn't hired as a result of his being older. In the other case, the employer had to eliminate one of the 4 positions and reviewed the files of each of these 4 people and eliminated the position of our 61-year-old instead of the 3 younger people. The case is otherwise exactly the same. The law says the employer cannot use age as a source of decision-making in this context, regardless of whether it's a decision to hire someone or a decision about who to fire. It's the same legal standard, it's the same evidence, and it's the same threshold. He has to show that age was a substantial motivating factor. The only thing that varies is hiring and firing. And hiring and firing are sort of very natural frames. If you don't get hired for a job, that's disappointing, but it's a foregone gain. If you get fired from a job, that's much worse. That's a loss, and it hurts much more. And there's much more much more attached to the loss, much more emotional System 1 reaction. So we wondered, would it affect how the judges think? And this is what we found. This is the percentage of judges that thought that age was a substantial motivating factor and the case should proceed. It was only 15% when his allegation was that the university had failed to hire him. But it was over 30% when it was that he had fired him. In other words, being fired triggered more of a System 1 emotional, sympathetic reaction to this litigant than failing to hire him. That loss triggered that reaction. It's just like the loss of $50 in a bet hurts. The loss of his job hurt the judges more, or it felt that was more egregious a form of conduct. Even though, again, the evidence was exactly the same, that System 1 reaction produced a different reaction in judges. Okay. So this, of course, has gotten us to wonder about judges' System 1 reactions to people, not just to numbers, not just to logical fact patterns, but what about to people? And I want to do a little thing here I've done this with judges. I'm going to put a word up on the next slide. I want you to think about your System 1 reaction to that word. Is it a positive or good word or negative or a bad word? I'll wait for natural. Fortunately, the same word in English and Spanish. Good, right? Natural is good. Natural is better. Everybody thinks natural is good. Natural is better. This was not always true. The chemical company DuPont in the United States, their slogan used to be better living through chemistry, which doesn't sound very, they've gotten rid of it. It's no longer their company slogan. But in the year 2019, at least in the US and Mexico, natural is better. This leads to a naturalness System 1 bias. Right? So there's pretty good evidence on this. So a good example of a study of this is if you give people a glass of water and you say, this water has natural levels of minerals. Drink it and see how it tastes, and rate it. They rate it as tasting better than if you give them exactly the same glass of water and say, this has had minerals added. They drink it. No, it's not as good. Even though it's the same water. Right? It just somehow tastes different, right? Added chemicals, no good. Light is the same way. If you put undergraduates in a room with filtered light so they can't tell whether it's natural light from outside or light from light bulbs, and tell them how quickly could you read under this light, and you tell them it's light bulbs, they say they read slower, and they do in fact read slower than if you're told it's filtered sunlight, even though it's always the same light. Turns out to always be light bulbs. The light is identical, but when told it's natural, it sounds better, and people read faster. Actually, a friend of mine on Facebook this morning just posted a thing about homeopathic remedies going, medicine is natural, not chemical. Well, that's not really true of most medicine you take, but people do rate medicine as better if it's natural. For example, vitamin C tablets. If they're told it's derived from citrus fruit, they think it works better than if it's chemically created in the lab. It's still vitamin C. It's the same compound. but people will rate it as better. This is my favorite. It's a little unnerving, I have to admit. But if you ask people, would you rather get skin cancer from exposure to the sun or time in a tanning bed? They don't answer, I'd rather not get skin cancer, which they should. Instead, they'd say, no, I'd much rather get skin cancer from exposure to the sun. Why? It's a horrible disease. I've unfortunately had friends who I've lost to it. It's awful. It doesn't matter what you got it from once you have it. But people would say, no, it'd be way worse to have gotten it from a tanning bed. Okay, so there's this naturalness bias. And we wondered whether this influences judges. It's sort of a way of getting at how they think about people. And so we've very recently done this is relatively new data. We've done a series of studies of how judges react to self-driving or autonomous cars. This is coming in the United States. There's actually a community in Arizona that has a fleet of autonomous taxis. When you call for the taxi on an app, it shows up. There's no person in it. You get in it. It drives you where you want to go. It works in Arizona because the weather's good. I'm not sure about upstate New York where I live just yet. So we wondered, what are judges' reaction to autonomous cars? They don't look like this, of course. They look more like this. Autonomous cars. And so what we did is we gave a group of judges a story about an automobile accident. We told them about a plaintiff who's a jaywalking pedestrian. The plaintiff is crossing the street while looking at her cell phone, not paying attention to traffic. Something clearly not advisable here. They get struck by a taxi while checking the smartphone. And the taxi is at fault because it's either we say it's a human being who's driving the taxi, or we say it's a self-driving car. I'm sorry, I've got this slide is a little confusing this way. We also, when it's a human being, identify, don't eliminate it just because it's confusing. When it's a human driver, we name the driver as Brad, Bonnie, or Deshaun. Okay, so we're trying to get a System 1 reaction to the type of driver and to whether it's a truly unnatural driver, an autonomous self-driving car. Okay. And so what we asked the judges is to assign a percentage of fault to the car or to the pedestrian. The pedestrian is partly at fault. She's jaywalking, looking at her phone, not paying attention. The car is also at fault. We say that the car, when it's a self-driving car, that its sensors were distracted by a light reflecting off a nearby building, an accident that actually happened recently in the United States. Or we say, when it's a human driver, that the human was distracted by light reflected off a nearby building. Right? So it's the same kind of accident. You're just allocating the degree of fault between one and the other. Right? And again, here, this is a more clearer slide. It's either a self-driving car or a human-driven car driven by either Brad Swenson, this was done in Minnesota, Brad Swenson, Bonnie Swenson, or Deshaun Jackson. Right? So that Deshaun Jackson is meant to, that's a name that is meant to get them to think the person is black or African American. Because Deshaun is not a name white Americans will typically use. Brad is. Turns out I have a colleague named Brad. I keep telling him, according to the Census Bureau, that's the whitest name in America. That European Americans are the only ones who use the name Brad. Bonnie is also a very, very white name. It's very uncommon among African Americans. So we're trying to signal a white male, a white female, or an African American male. Right? And this is the percentage of judges that attribute more than half of the fault to the car. If more than, and this is a key number because you don't recover in Minnesota unless more than half of the fault is attributable to the defendant. So this is really telling you which percentage of the judges would find in favor of our plaintiff and award some damages. When it's a self-driving car, it's close to 70% think that the car is mostly at fault. When it's Brad, it's about 40%. Brad, that's a pretty big gap. That Brad is not blamed nearly as much as the self-driving car. He's a natural driver. We're familiar with humans driving cars, not so much with these self-driving cars. Bonnie, we don't trust as much. And Deshaun, I don't know about him. Right? The judges did have a different reaction to Deshaun and Bonnie than they did to Brad. Somewhere in between the foreign, unnatural self-driving car and what they think of as a natural driver, Brad Swenson, the taxi driver. We've also replicated this in an interesting way very recently, and the data are still a little raw, so I'm not presenting them. But where we said that the driver was definitely at fault, we asked to identify a damage award. So the driver is definitely at fault. The pedestrian's no longer jaywalking in this version of it. What's an appropriate damage award? And the injuries are all the same, but they award more when the person's hit by a self-driving car. We're going to title the article, I think, "Would you rather be run over by a self-driving car or a car driven by a human?" And clearly, people would rather be run over by cars driven by humans than self-driving cars. And these are judges, of course. They're having this System 1 reaction, even though the accident is very similar. And that System 1 is affecting how they're judging the people as well. Right. Let me do another word association. This one, the word is not the same in English and Spanish. We'll give you the Spanish version. Is this a good word or a bad word? Foreigner. In the United States, the judges, they don't like to admit it, but they do have a negative reaction to that term. I notice in Mexico City, it's true in the United States too. When you arrive from a foreign country, it says, extranjeros and Mexicanos, and you go, and the line's shorter on the Mexicano side. Going back in the United States, it's the opposite as well. Like American citizens, you always get the short line. Foreigners, it's a negative term, almost politically incorrect in the United States to use the word foreigner. And we wondered about judges' reactions to foreign and domestic individuals in a way that shouldn't affect them. In the United States, we wondered whether judges favor litigants that are from their home state. So in a sense, not really foreigners, that they're not, they're all U.S. citizens in our hypothetical, but there's a long folklore in the United States that judges don't like litigants from out of state. I sometimes put up a quote here from a judge, in fact, it was the Chief Justice of the Supreme Court of West Virginia, who announced in his autobiography that he deliberately finds against out-of-state litigants so as to transfer wealth into West Virginia, which is a relatively poor state. Right? Most judges think that's wholly inappropriate. It's not how you should decide a case. Shouldn't decide against someone just because they're from a different state of the United States. But in fact, we suspect judges do that anyway. So we did a study in Minnesota. Now, Minnesota is in the north part of the Midwest. It borders on Canada. And it has, for our purposes, fortunately, a rivalrous adjacent state, Wisconsin. The two states, I did not grow up in this part of the United States. It's the northern Midwest. It's very cold in the winter, even more than New York. These two states, to my eyes, are indistinguishable places. They're demographically almost the same. And if you say that the two states are indistinguishable with audience members from Minnesota or Wisconsin, they will accost you afterwards and complain and identify the many ways these two states are very different from each other. They're not. But they think of themselves as very distinct. They're rivalrous states. They play their college football teams. The University of Minnesota and the University of Wisconsin play a homecoming game against them. That's the annual rivalry the schools build up to. Their professional hockey teams are bitter rivals. Their professional football teams are bitter rivals. They go on about how different the two of them are. They don't like each other very much. And we had a group of judges. In fact, it's most of the trial judges in Minnesota at a research conference, and we wanted them to participate in a study in which they were going to award punitive damages. Punitive damages are damages meant to punish someone for particularly outrageous or egregious conduct. So we gave them a fact pattern. These are all Minnesota judges. A fact pattern involving whether someone should be awarded punitive damages, and if so, how much. So we told them a story about a defendant who's the owner of a small company that is basically polluting a lake in Minnesota. This company, they deal with hazardous chemicals, and instead of disposing of them properly, the chief executive officer of this company decides to dispose of them all in a lake, which turns out to be on private property. It's 20 miles away from his headquarters. There's a plaintiff is the owner of this property. We tell them he's a farmer in Minnesota, which has a particular connotation in Minnesota, a very esteemed group, Minnesota farmers. And the plaintiff owns this lake, and he swims on it in a summer day right after the defendant company had dumped chemicals in the lake, and he gets very sick. He suffers severe arsenic poisoning as a result. We may have overdone it a little. He loses one of his kidneys. He's nauseous all the time. He has constant headaches. He's got facial disfigurement from exposure to the chemicals. He's very badly injured. Okay? And we tell the judges that the compensatory award, the damage award meant to compensate him for these injuries, has been settled out. The parties have agreed on an amount. What they don't agree on is whether there should be an additional amount to punish the defendant for particularly outrageous conduct, punitive damages. So the judges have to make two decisions. They have to decide first, should punitive damages be awarded? They virtually all did think so. In fact, the conduct is quite outrageous. So then the question is, if you award punitive damages, how much? And again, we varied one thing. For half of the judges, the defendant is also a Minnesota citizen, also a company from Minnesota. So in that case, we have a Minnesota plaintiff, and an injured party from Minnesota, and a company from Minnesota. It's all in-state, all in the family, as it were. For the other half, it's someone from Wisconsin, from this rivalrous adjacent state. The distance traveled is always the same. It's 20 miles away. The conduct is always the same. The chemicals are the same. The disfigurement is the same. The only difference is the identity of the defendant. There's no legal import to the fact that he's from Wisconsin. Doesn't matter that it's crossing state boundaries. It's all within the United States. It's the same injury. But here's what we get. So when it's a Minnesota defendant, the median award is $1 million. It's a high award, but it's particularly outrageous conduct, so it seems appropriate. When it's one of those damned Wisconsinites, it's $1.75 million. So it's 75% higher when it's a foreigner, when it's with someone from a foreign state. We have replicated this with two pairs of other states. The effect is a little smaller. I don't know how well you know the United States. It's New Jersey and Pennsylvania. They're not as rivalrous. Half of New Jersey doesn't like New York, and half of New Jersey doesn't like Pennsylvania. So it was harder to come up with a rival. And then Ohio and Michigan, in which they don't view themselves quite in the same posture as Minnesota and Wisconsin. But we see the effect over and over. Someone who's just a little different gets treated much worse by trial judges who should know better and, in fact, disavow the idea they should treat them differently. So, of course, this has gotten us to wonder about, well, how far does this go? How much bias can we see in judges? And one of the things judges worry very much about in the United States is whether they're treating litigants of different races differently. So much so it's actually very hard to study it. It's one of the most difficult things we have to study with judges. You can see a little bit of it when we varied the name of the driver in that one study. They were willing to think that Deshaun was a much worse driver than Brad. But that's the kind of context in which we do see effects, where there's a lot of discretion for judges, where they're not likely to be reviewed, and when we're subtle about the name. When we try to study disparities in sentencing in criminal context among judges, we typically don't see any difference using our methods. Now, we know there are differences out there in the world. When we look at sentencing data from real cases with actual defendants, judges tend to sentence African Americans more harshly than Americans of European descent in the United States, and Latinos are typically somewhere in between. We know that data exists. We don't quite know why it happens. Judges like to say, essentially, it's not their fault, that they treat litigants alike, but there's a lot of other actors in the system, like prosecutors, like probation officers who recommend sentences, in which there's pretty clear evidence of implicit bias and disparity. So the judges may be more neutral on sentencing. We don't entirely know, but we don't see that in our study. But we can see implicit biases of this sort in judges, just like we do with the self-driving cars, just like we do with the out-of-state litigants. In fact, this is a slide judges particularly like. These two individuals, only one of the two of them has seen the inside of a federal prison. It's not the one you think. This is Martha Stewart and a rapper named Snoop Dogg. They have a TV show together, oddly enough, a cooking show. It's a very odd. Martha Stewart, of course, went to prison for securities fraud. Snoop Dogg has never been in a federal prison. To be fair, he has been inside a state prison. He really likes marijuana, turns out. And oddly enough, they're making brownies in this slide. It's a little unnerving. Your first intuitions can be wrong. Martha Stewart is the federal felon in this hypothetical, not the person who looks a little differently. We know in some contexts that triggering race does tend to produce different implicit biases among lawyers. This is not a study of judges here. It's not one of my studies, but there's a really good study that the American Bar Association did a few years ago. They wrote a case brief, a memoranda of law, It was a 5-page brief, and they wanted partners at major law firms to evaluate the quality of this brief on a 5-point scale, which is actually very common among law firms in the United States. They rate attorneys' work on a 5-point scale to determine who gets promoted, who doesn't, and the like. And the brief was not very well written. It was evaluated by 60 partners. The brief contained several errors, including spelling and grammatical errors, which I tell my students never to do if you're turning something in to a partner at a law firm. And the question kind of is, to what extent would these partners overlook these errors? And what they did is they varied the identity of the author. For half of them, they were told that it was a European American, a white American who wrote the brief. In that case, it was rated somewhat poorly, 4 out of 5, which is kind of bad. You're supposed to get 5 out of 5. So they did notice there were mistakes. But when they were told it was a black associate, it was like 3 out of 5. It's like a full point below. And 3 is unacceptable. You don't have a future at a firm with getting 3s out of 5s on these ratings. So it's really the difference between, okay, if you made some mistakes, we might forgive, and no, this is unacceptable work. And when they're told it's a black litigant associate, then they're less forgiving. That tends to be how implicit bias often works. Are you going to overlook something in a litigant? Let them slide, go a little easy on them, and it might be a little different depending on the source. Again, we don't see this when we study sentencing. The judges are very uniform in terms of sentencing black Americans and white Americans the same when we use hypothetical questions of this sort. They're very good at that. They're very much using system 2 thinking. And I often tell them, keep using that thinking in your courtrooms. Whatever you're doing in my studies on sentencing, keep doing that. Because we're not seeing any differences by race. That implicit association that's negative, we're sure is there, but it's just not being triggered, or it's being overridden by their system 2 deliberations. But we do find instances in which judges do, in fact, rely on system 1 in judging people. You saw that a little bit with the self-driving car, but let me give you another example. This is an area of law where we think there's a lot of influence of implicit judgment, family law. There's a lot of discretion judges have in deciding various aspects of family court cases. They're essentially judging people as parents, which is central to how most adults think of themselves. And so it's a fraught area where there's enormous amounts of discretion among the judges, and it's an area that's very prone to system 1 thinking. So we gave 200 judges, these are judges from Connecticut, a state in the Northeast, a family court decision, a somewhat complicated one where they have a lot of discretion. We told them a story about a divorced couple. We told them there's this couple, they've got 2 young kids, they've been divorced for 2 years. The father is a legal resident alien of the United States. He's not a U.S. citizen. And part of what caused the couple to part ways and get divorced is he wanted to move his family back to his home country. The mother is from the United States. She's never lived abroad, and she did not want to live in a foreign country and insisted on living in the United States. So this father had to forego a number of job opportunities to stay, and eventually it caused a lot of bitterness between the two of them, and they kept fighting and eventually got divorced. At one point during the course of their divorce, the father threatened to take the 2 young children back to his home country and stay there without the mother's permission. This caused the court during the divorce proceedings to give the mother not only custody of the children, but also of their passports and issue a travel order that the children could not travel more than 50 miles from their home without the mom's permission. So that's the way the divorce settles out. The dad is a non-custodial parent, the mom is a custodial parent, and she has control of the passports, so the dad cannot take the kids out of the country. A couple of years pass, the father comes to court, and he asks the court for permission to lift the travel order and give him access to the passports for a 2-week trip he wants to take to visit his extended family. He claims that his mother is very sick and cannot come to see her grandchildren, that he wants his children to be connected with his extended family and to see where he grew up. All reasonable requests, but the concern is, of course, that he won't return, that he'll make good on his one-time threat to more or less kidnap the children and take them and stay in his home country. Okay? The father explains that he didn't mean to threaten the mom during the divorce proceeding, that was he only did it once. He was very angry. It was part of a bitter divorce, and then he has no intention of kidnapping the children. He wants them to come back to their mom. He just wants them to see their extended family. The mother, nevertheless, is nervous. She opposes lifting the travel order, and so both parties go to court to decide, should this person be allowed, the father be allowed to travel to his home country or not. It does happen. It's not the most common family court case, but it does require judging who the father is and what he's about and how trustworthy he is. Really the kind of thing that implicates implicit biases. And it's an area where there's very little law to rely on. There's no System 2 guidelines. So we ran, of course, 2 versions of it, like we do for everything. For half the judges, the father's name is Ron McDowell, and he's from Ireland. The other half, it's Raj Mandpur, and he's from India. Now, we didn't choose these 2 countries randomly, of course. Ireland and India both, in some ways, have very similar legal systems. If you do research on the internet, you can find cases in which parents have abducted children to Ireland and to India and gotten them back or not. It's complicated. The 2 countries really are very similar in terms of their legal systems. There's some concern about corruption among the judges in India, but it's not clear which way that cuts. Corruption works for you if you pay. So it's, and the real question, of course, is whether or not the dad is going to come back. Not how easy is it going to be to get the kids back if he doesn't. If the judge thinks the dad will not return after 2 weeks, he should not lift the travel order, or she should not lift the travel order. If he does think that the dad is trustworthy, then it's okay. And there are lots of similarities, as I said, between these 2 countries in terms of how likely it is that you get the kids back. So what did they do? Well, Ron McDowell, they kind of trust Ron McDowell. 3/4 of the judges thought he could go. Raj, he's not going. 40% of the judges thought it was okay, but the foreignness sounding name, Ron McDowell, is a name you'd encounter in Connecticut. Raj Mandpur, less so. We think is what's triggering that very System 1 reaction to them, that India seems more remote and distant and foreign than Ireland does, even though, of course, there are many Indian immigrants in the United States these days. It just feels and sounds different to them. We have duplicated that with Ron McDowell and a Japanese name. It's Ronin something. I forget the name we used. So Japan also seemed a little more foreign. It's somewhere in between, though. There was more trust of the Japanese litigant than the Indian immigrant. But we do still see the effect. It's how foreign does the name sound. It's like those damn Wisconsinites. It just sounds different, feels different, triggers that different reaction. All right. I don't want to. I've given you some of the evidence that judges are not all System 1 thinkers. That judges, when they're doing sentencing, really do stop and think and deliberate, and they do suppress their intuitions in our research, at least, if not in the world. It's a little more complicated. But one thing we worry about, and I'll end with this phenomenon, is something the psychologists call the egocentric bias. So the basic theme here, of course, is System 1 is overconfident, right? That if you decide something with intuition, you make an overconfident judgment, perhaps. It feels like it's right. And one of the problems is, what if you feel that you're accurate all the time? Most professionals, it turns out, think they're very good at their jobs. If you do surveys of people and ask, are you better than the average person at what you do? A good 80 to 90% of most people say they're better than average. Driving an automobile is a good one. 85% of drivers say they are safer than the average driver. That's impossible. It has to be half and half. But most people think they're better than average. University professors are not immune. 95% of university professors think they are better teachers than the median teacher at their university. Can't be. But if you don't think you're better than average, it's a very demoralizing job. Right? What does that 5% think? Oh, yeah, I'm way worse than my colleagues. I'm terrible at this job. That's this slide. There's one group of people who are very accurate. People who suffer from clinical depression tend to have very accurate assessments of their own abilities. I love this slide. I suffer from accurate self-esteem. You don't want to suffer from accurate self-esteem. You want to be overconfident. It's healthy to feel that you're right most of the time, but it's an impediment to good judgment. Course. For lawyers, this is true. Most lawyers think they're better than average. Here's an example I like. Lawyers report that only 5% of the legal documents they read are well drafted. But they claim that 95% of the documents they write are well drafted. Well, who's writing all these bad documents? Right? I read a lot of junk, but I'm not producing it myself. That's overconfidence. And for judges, I'm going to give you two examples of things that are real problems for judges. For judges in the U.S., it's important not to be reversed on appeal. So we asked a group of federal judges, in fact, relative to judges in this room, are you more or less likely than the median judge to be reversed on appeal? And 88% said they were less likely than the median judge to be reversed on appeal. Oddly enough, a few of the judges that said they were more likely to be reversed on appeal came up to me afterwards and said they were proud of the fact they were reversed often on appeal because they did not agree with the appellate judges' politics in their jurisdiction. So even then, it was still a source of pride, right? I get reversed, but I want to. So most judges think of this as very important, and they, of course, think they're better than average. One difficulty for judges on some of the implicit biases we're concerned about, we asked a group of judges, these are state court judges, relative to other judges at this conference, how would you rate yourself in avoiding the influence of racial bias on decision making? 97% say we're better than the average judge at avoiding racial bias in decision making. Actually, in that group, there was only one judge who rated himself as worse than average. We do not know who that is. He she did not reveal themselves later. That's healthy. Of course, we want judges to think they're unbiased and to act as if they're unbiased and to present any image of the unbiased judge. But we know from some of our research that they're not unbiased. And so one of the impediments to improving judicial decision-making is exactly this egocentric bias, convincing them that sometimes they are actually wrong. So I'd like to conclude then, look, what do we know from my research? That intuitive thinking can lead judges astray, even in contexts in which they should be experts and they know better. And that intuitive reaction facilitates the kind of invidious biases like deciding against Raj Manpur or deciding against the one driver of the car that sounds like he's African American. Those invidious biases can influence judgment. They don't always, but they can influence judgment among judges. And that what judges need to be better at their jobs is to stop and think. The same thing most adults need to be better decision makers. Mechanisms to slow themselves down, to think deliberatively, to rely more on the rules that are in front of them than their impressions of litigants. However, when all is said and done, judges are human beings. They have their limitations. So I want to end on that slide. Thank you.
Thank you so much, Jeffrey, for that excellent presentation. I think we have, I think we have a lot of material to work on, and I'm sure a lot of the people in the room will have questions to address our speaker. I think I'll just throw 2 or 3 questions to you very quickly, and then I'll open up the microphone. Perdón, voy a cambiar español. Well, I'll address the questions in English to you. My first question would be, if you look at it on a cross-country perspective, do we see the same trends? You know, your research results can be taken to other countries and cultures. That would be my first question. My second question is, what are the consequences of your research for justice? You know, for real justice in the U.S., and I would like to listen to your conclusions. And my third question, very quickly, would be, what can the legal and judicial systems do to neutralize biases? So I'll leave those 3 questions. I'll leave you to answer them, and then we can open up the microphone.
Well, those are very big questions, so thank you for those. Cross-country, you know, we don't know as much. What we know from social psychology is that intuitive reactions to people are ubiquitous. That they're, I often argue with my students about this. Many of whom are very well traveled. I'm fortunate many of them are from other countries. They will identify sometimes one place or another where they think is free of bias. There is no such place. That's this. Maybe in heaven we're all free of bias, but here on earth we live with human beings. People draw associations about other people, both positive and negative, and it's very hard to get rid of them. If you think of that slide about Snoop Dogg and Martha, in the United States, everybody laughs at that slide. They know exactly what I'm getting at. That Martha Stewart does not look like a felon. Snoop Dogg is trying to look like a felon. He's selling more records that way. And there is a look, and I've some other data, which if you're here tomorrow, I'll present some on that judges do rely on physical appearance and what people look like. That is kind of ubiquitous. So the social psychology part, do we see intuitive reactions to people? That part we see pretty much everywhere. It's hard to identify a place that you just don't see a bias, where you can't identify an out-group where people have more negative reactions to. As to do judges react to those biases in different countries, we know very little. The research we've done in the United States on judges is not the only research done on judges, but it's close. And the United States we're fortunate, we have very good data on sentencing, so I can confidently say I know African Americans are sentenced more harshly in the United States than white Americans, because we have a mountain of data on it. This gets studied a little less in other countries. The United States, certainly we have many racial problems, but researchers are very upfront about addressing them. I was talking at dinner with Alexandra last night that I do a lot of research in Canada, and I'm very grateful to the Canadians for doing that. They won't let me study racial biases in Canada. They will not let me give hypothetical questions involving implicit biases on race. They did let me study gender, and I have some data. I'll present some of it tomorrow. In a certain family court problem we've run in Canada and the United States, and actually in Switzerland, we see a very big gender bias, and we tend to see it among people that harbor strong associations about gender roles, which is not everybody. That varies a lot. And so we do see the effect of implicit biases on gender. But racial biases, ethnic biases, the data are very, very thin. It would be very surprising if we didn't see them. Different legal systems are a little different. I'd be very interested in getting more data from the Netherlands. It's a somewhat racially homogenous country, but not purely. And so that would be a good place to study, because I have this data that they're very much System 2 thinkers. Their judges are much more like mechanical engineers than judges in the United States and in Canada. And so that would be an interesting group to try to test this out on. Consequences for justice, well, that's huge as a question. I would maybe put the kind of cognitive biases I've studied in two categories here. One, maybe just the sort of cold cognitive biases. Phenomena like anchoring and framing do arrive from intuitive System 1 thinking, but they don't have sort of systematic implications involving disadvantaged groups necessarily. The framing and anchoring do definitely distort the legal system. I've got two papers on this. You can find very specific doctrines in law that are influenced by those two cognitive phenomena, and so they do tend to affect how law develops and how it's applied on the ground. So they are real effects, but they're real effects for kind of everyone in the system. So anyone who's got a lawyer who's smart enough to use anchoring is going to benefit. And framing just does create disadvantages for people who are litigating over foregone gains as opposed to losses, regardless of who they are. But by and large, they create an erratic source in the legal system that judges should be mindful of, should slow down, should try to prevent, because those are miscarriages of justice. But in fact, they're not systemic in the way that they affect groups. The other category of biases I've studied involve litigation involving out-of-staters, foreigners, involving, I'll have some more data on gender bias that I'll present tomorrow, and racial biases. Those obviously affect different groups differently in ways that we need to be concerned about. I think particularly in family court, that's been a rich area for us. That's an area where the judges have a lot of discretion, where we actually have very much more limited data. Criminal sentencing in the U.S., we know a lot about it. Family court decisions, we know a lot less about. And that's an area where judges, if they're being honest, will admit that they do rely on their impression of what a family should look like and what it should not look like. And it's very difficult for them to put that aside. I do a lot of work, for example, with bankruptcy judges. That's very similar. In bankruptcy court, judges are kind of forgiving debts. Now, there's a lot of structure to it. There's a lot of law to apply. There's a lot of areas where there's no discretion. But areas where they get discretion, judges admit that they, in fact, look at the debtor, and if they have this feeling like, I could have been in that situation, or very commonly among judges in the United States, my son or daughter could be standing in front of me. Right? I see that among judges, that they identify not so much with themselves for criminal defendants or bankrupt debtors, but with their own children. Because in the U.S., they tend to have kids who are in their late teens, early 20s, and judges will tell me that. They'll read a problem and go, my son did that. And that really has an influence on their judgment. But of course, their son is someone who is a lot like them. Right? That's someone in the same socioeconomic group, and they have a lot more trouble empathizing with people who look and sound differently. And we have a fair amount of data on that. And of course, that leads to how does one neutralize bias? I think for many of the colder cognitive phenomena, there are well-studied debiasing techniques. So anchoring has a fairly standard debiasing technique to it, which is basically to identify reliable and sensible anchors, more or less displace the misleading ones. And we've tried that with judges as debiasing strategies. It works pretty well. Framing is a little harder. What you want to do is imagine the foregone gain as a loss and try to trigger the same intuitive reaction. Right? So it's almost imagine the opposite. That works reasonably well as a debiasing strategy. Overall, we tell judges rely more on the rules. Don't use your discretion as much as you're allowed to do. Follow guidelines, follow scripts, ask other people about cases, particularly clerks who work for them. We tell judges, run things by your clerks. They'll have a different point of view. They might not be subject to this. They might not see the case the same way, might not be subject to the same kind of bias. Neutralizing race and gender bias, there's a lot more written about that. And there are some pitfalls. So one of the things, interestingly, that social psychologists have found that does not neutralize race or gender bias is acknowledging that you have race or gender bias. It sounds like a nice first step, but in fact, there's some data that giving judges a lecture on invidious biases leads them to engage in more bias afterwards. It's something the psychologists sometimes call moral licensing. It's like, I'm a good person now. I listened to a lecture telling me I'm biased, so now I don't have to worry about it. You actually have to give very concrete strategies to judges. And on racial bias, again, we do tell judges, don't rely as much on your discretion. Try to empathize with the person. Try to imagine they're a different race or a different gender. That only works so well. But we do tell judges to try to do that as best it can. But one of the things I'm really worried about, and I struggle over in thinking through what to tell judges, is remember that the way invidious bias is often working is empathy for a person and giving them a favor or granting them something they're asking because you empathize. So the judges who see Ron McDowell so say, well, okay, he did something foolish. He made a threat he should not make. But many parents do that in the context of divorce. And he seems like a good guy. But they don't have that reaction for Raj. Right? It's just they can't get the same empathy for a foreign-sounding individual. So what's the advice to judges then? And it's something I don't know what to tell them. Is it to be hard on Ron? Right? To put that empathy aside, to call that misleading and say, no, you shouldn't be so nice to Ron. You know, he's a bad dude. He shouldn't go. I mean, he's not coming back. Ireland, he's a kidnapper. I don't like that outcome because judges should be empathetic. They should think of the person in front of them as a human being. But then, what I would like is for them to trigger more empathy in someone who's very different from them. That turns out to be harder to do. So triggering empathy is a system 1 remedy. So most of my remedies, in effect, are system 2 remedies for system 1 problems. Stop and think. That's the message. But in effect, for some of the racial biases, I kind of want a system 1 remedy. And I want to tell them to empathize with the person, but I mean empathize, but you just say, okay, I'll empathize with someone. It's something you have to kind of feel. And so social psychologists are still struggling with that one, that what can we do to get people to be more empathetic? Because, and you see it in many systems of justice in the United States. Many school systems in the U.S. are struggling with this now. There are huge disparities in discipline for Black and Latino school children compared to white school children. And you find that a white school kid caught with marijuana in the school bathroom is likely to be told,
Don't do it again.
don't do it anymore. You're a bad kid. And maybe they'll tell the parents. A black kid's going to get suspended. And you want to say, well, is the answer to that to suspend the white kid too? Maybe, right? So that at least we want it to be even. I think the answer is more to just try to find a way to empathize, because the motive behind not suspending the white kid is a good one. It's kids make mistakes. We don't want to ruin your life over this. We still want you to go to college, but we want you to stop doing this. That's a human altruistic motive that I like. I just want to see it for everyone in the classroom. But then then there is also boomerang effects, where then my school system at the moment, there is no penalty whatsoever for using or selling drugs in my high school, as far as I could tell, where my kids go, because they're worried about this, and so they've just decided they're not going to discipline anybody. It's not right either. I'm sure it's not right. So it's a hard question in lots of ways, but we should take questions from the
thank you very much. You can have 2 minutes to have some water.
Okay.
Vamos a abrir si quieren el micrófono. Les pediría nada más que traten de ser muy concretos, de hacer como una pregunta y no introducciones muy largas para la pregunta, y así podamos tomar más preguntas para nuestro ponente. Tenemos un micrófono, decidimos hacerlo a micrófono abierto para hacerlo un poquito más rápido, más que con los papelitos. Entonces, bueno, adelante, por favor, levanten las manos quienes quieran hacer alguna pregunta a nuestro ponente.
Will you translate, or
She'll translate.
okay, so I can.
If you
Hi.
need help.
I need a lot of help. Go ahead.
Hi. So, can you see me? Hello.
Yes. Hi.
So-
Si quieres presentarte nada más tu nombre, si quieres, y de dónde vienes.
Melissa, I'm from the School of Psychology.
Hello.
So, one of the things that has we always hear about stereotypes, that the bad thing is not that they are wrong, but that they are an incomplete account of things. So all of this research that you presented, I have the question, when we think about ways to get past our shortcuts to process information, if we are confronted with the other side of things, or the fact that we are systematic, that we have a systematic bias, how do people respond to this? If you have done any research regarding this? For example, the bat and the ball problem, if we are confronted with the right answer after having done, after having producing the wrong one,
Okay, I see.
does that help, or are you familiarized with this?
I understand. So the question, I take it, is how do people react when they're confronted with the right answer? Does that help them learn and overcome their error or not? So that's a complicated question and an excellent one. On some problems, like the bat and ball problem, most people will recognize they've made a mistake when you give them the right answer and walk through it. For some people, it takes a little while. Actually, when I present that problem to judges, almost inevitably, at least one judge will confront me after the presentation and tell me I'm wrong. No, it's 10 cents, Professor. And they'll have some rather bizarre explanation for why. And it takes a lot of work to convince them that it's 5 cents. That little slide doesn't do it for most people. I even have a joke in some of the presentations. I do the explanation for why it's 5 cents. I typically will stop and say, and I know some of you still don't believe me, because they don't. But eventually you can get people to, that is a logical error, and there's typically a way to get people to show that they've made a mistake. On things like framing, often people will also argue why gains and losses truly are different. And in some contexts they really are. It is actually true that being hired and being fired are different things. So there is some logic to it as well. They're not in that context, so it's an overused heuristic, as it were. But there are many contexts in which gains and losses are not truly the same thing, just mirror imaged. So often the reaction is to argue about it, and that's system one at work. That's the intuitive system, just being convinced that you're right. But on many of the logical problems, people will, in fact, ultimately give up, and they will see that they've done something wrong, and then start to look for different ways to think about problems of that sort. One of the difficulties is that, with debiasing people, is that even when people develop a particular strategy for getting a problem right and avoiding the kind of misleading System 1 impression, often it's very domain specific. So they'll be good with bats and balls, but you put other things in there, they get it wrong again. So it's very hard to get good generalized debiasing techniques. They'll often get the same problem right, but then something with a slight variation, they'll still get it wrong. On race and gender bias, the situation is much more complicated, of course. People first do start out arguing that the heuristic is an accurate one, right? They'll say, well, you saw that picture of Snoop Dogg. Doesn't he look like a drug dealer? He is trying to look like a drug dealer. Well, he's wearing a suit. He's nicely dressed. He's making brownies. There's a lot. The interesting thing about race and gender stereotypes is it's one of the few areas where, in fact, people will rely on background statistics. So if you're in a bad neighborhood and seeing someone dressed in a particular way and you're judging them as a potential criminal, as opposed to someone maybe dressed the way I am. I never get judged as potential criminals, it turns out. If you dress in a suit, you're a white guy, you're a professor, nobody thinks you're a criminal. If you're dressed in a different way, and people will say, look, the base rate is different. Judges will sometimes say that about sentencing. There are more African Americans. The crime rate is higher. But in most areas of human judgment, people don't rely on those background statistics. They won't say, well, more African Americans are criminals or this or that. They'll judge people individually or judge things individually. They don't rely on numeric background statistics like that, but they do for race and gender, and they very much over-rely on them. So you have a problem at the outset that people can point to crime statistics that suggest that they should be more afraid of someone. They're not really right about that, and it is very hard to disabuse them of that. And give them a different way of thinking. It's one of the great challenges of social psychology. And I recognize that's an incomplete answer, but what we're kind of working on as a discipline, and you may be working on as well, is how do you empathize with someone who looks very different? That's a deep human problem, and it does not admit of a simple, easy answer. And thinking of the person as a human as opposed to a number or a statistic or a category is one of the challenges of human existence. So I'm not going to be able to answer it in a short time. On the cognitive problems, once people recognize they're wrong, you can teach them debiasing strategies. Again, the trick is learning it well enough that you use it in different domains. On judging humans, it's actually a lot harder.
Gracias. ¿Alguien más tendrá alguna pregunta? ¿Alguna mano levantada por acá? Gracias.
Bueno, muchas gracias y muchas felicidades por la conferencia. Su trabajo ha ayudado a visibilizar estos prejuicios, estos sesgos cognitivos. ¿Cómo hace la psicología jurídica en Estados Unidos para minimizar estos efectos de prejuicio en los juzgados?
That didn't work at all.
No, it didn't work.
No.
¿Nos repites la pregunta?
Sí. Usted ha hecho visible este problema
You have made visible this problem
de sesgos cognitivos en jueces.
of cognitive biases in judges.
¿Qué hace en Estados Unidos la psicología jurídica para reducir estos sesgos?
What is legal psychology doing in the U.S. in order to reduce these biases?
Oh, yeah, it's not a big field. You know, I mean, honestly, I'm one of the very few people working on debiasing judges. I do have a lot of cooperation, though. So the Federal Judicial Center, which is the principal education center for judges in the United States, has me speak to basically every new judge in the United States. So part of why I have 5,000 judges is I spend a lot of time, one judge at a time, explaining cognitive errors to them. It's really a growing field, though, in the sense that judges themselves are very interested in avoiding error. And so in a way, it's more the case that judges are interested in finding out how to make better decisions than it is that academic psychologists are trying to improve judges. So it's really more judges looking for solutions themselves. And what I've found is happening is that many judges who have heard my presentation or read Daniel Kahneman's book or both, and have learned about the field of errors in cognitive reasoning, often will hold conferences of their own for their colleagues. And judges are very good at listening to their colleagues, more so than academics. And so it's what's really happening in the United States is more judges know about this work, increasingly so, and they are trying to find ways to educate each other on it than psychologists really trying to improve judges. Thank you for the question.
¿Alguna otra pregunta? A ver, por acá. It's not working? Or
No, I didn't hear anything.
Ah, here. There you
Is
go.
yours working?
Yes.
Okay.
Very clear your presentation. I'm going to speak in Spanish. Digo, in Spanish, my English is very bad. El autor que manejaste, digamos de psicología económica, bueno, habla de dos sistemas. El intuitivo, que primordialmente usan los jueces, y uno más racional y exhaustivo, a través tal vez de investigaciones. ¿Habrá, digamos, un tercer sistema no advertido, por ejemplo, el óptimo Pareto, en donde entre dos situaciones complicadas, bueno, se determina la que no perjudique a las dos partes, como una especie de ganar-ganar? ¿Habrá algún esquema que se pueda manejar en materia judicial?
So thank you for that question. The question actually points to maybe an oversimplification in the talk and in how psychology gets described. In fact, I've had many psychologists react to this talk by saying, I don't really know what System 1 and System 2 are. That doesn't really map onto anything in the brain. But I find it a good pedagogical tool. It's a good simplification. And it's one that Daniel Kahneman has worked on, and it's really a means of conveying a way of understanding the psychology more so than that there really are systems. No neurologist would look at that talk and say, well, of course there are two systems in the brain. There aren't two systems in the brain. There are many different ways that we think about things. But there does seem to be this nice dichotomy between thinking very quickly and thinking more slowly and more carefully that does map onto a lot of the judgment decision-making literature. So trying to identify a third system, I don't think is quite right. But what you point to is it's very clever. The real gap between the two is understanding the role of purpose and motivation of the judge. What does the judge want to get out of the proceeding, right? And System 1 and System 2 don't really give us any insights into that, except to say that the purpose will probably drive a lot of their thinking. So if the judges have a mindset or a schema for how the case is going to come out, that is likely to guide a lot of their decision-making even if the judge doesn't fully recognize it. That's system one. But identifying what that schema is or what the judge's motivations are is really not something that framework will really tell us a lot about. What we can learn, as I said, is that it'll have a much bigger influence on the judge than we think. And so that's why training judges to identify good compromises, good ways of both parties winning, is its own skill. And so, in fact, many judges in the United States spend a great deal of their time as mediators between the parties to try to get the two parties to reconcile. And there is a skill set associated with that process that is exactly what you're talking about, the win-win. And I think it's asking a somewhat different question than what I'm asking. I start out with the assumption that judges are trying to get the facts right in some objective sense, that they're not trying to over-ascribe negative motivations to certain parties or over-attribute fault or blame to people because of their name or something silly like that. I assume that all judges share those motivations. It's like when I study the difference between Minnesota and Wisconsin and those judges, I assume all those judges actually want to treat those litigants the same, that is their underlying motivation. It may not actually be true. As I said, there is this judge from West Virginia who said, I don't care about that. I just want my people to win. That's a different motivation, and I don't think we speak to that very well in this literature. It's not that it isn't a vastly important topic. It's just that what I'm looking for is tools to give judges to get done what they want to get done. I have a great deal of faith in judges in the United States that they do want to be fair, they want to be honest, and that they want to get the right result. Of course, if those things aren't true, then really very little of this matters. I had a question once from a judge in Bangladesh that says, we have a lot of corrupt judges. I'm not sure you have anything to say to me about that. And I said, I'm not sure I do either. If you could just buy the outcome, that's really a different problem than I'm worried about. I do take judges to be professionals in many cases, in many contexts, and to want to get things right. And my talk is really directed at them. Yours is even a more subtle question, though, that we can take judges' motivations and improve on them to try to get them to reconcile disputes between parties in ways that are mutually beneficial, more so than just trying to find a winner or a loser. And I do agree with that. It's just a somewhat different project.
Por acá.
¿Qué tal? Muchas gracias por la presentación. Un problema que quisiera que me resolviera es si realmente en el sistema 2, porque pareciera como que estamos hablando solo de la opción intuición y la opción reglas, pero me parece que aquí el peso del conocimiento científico mismo no queda resaltado. Es decir, porque en reglas podríamos tener reglas para tomar decisiones, que es el caso mexicano, o se supone, o que ha existido en otros casos, como el sistema tasado, en fin. Y el problema es cómo vamos a tomar la ciencia misma. Es decir, de hecho, la que usted mismo hace, es decir, ¿la psicología es una ciencia de a de veras? Yo creo que en muchos casos el peso de la ciencia misma varía en la percepción del juez y va a tomar con mayor importancia, o le va a dar más importancia a unas que a otras. En particular, digamos, las ciencias sociales, por un lado, las ciencias naturales, que también en este juego del natural ahí pesa, o duras, pues, van a tener distintos pesos. Lo que hace el criminólogo va a ser distinto, va a tener un peso distinto que lo que hace el criminalista. Pues. En fin, entonces me parece que aquí también tiene que ver cómo va a ser, cómo separamos, digamos, un poco pensar a través de reglas y pensar a través de la ciencia. Pues.
So that's an excellent question. Actually, it's a question that most psychologists, when they think about the legal system, spend most of their time thinking about. How can we convince judges that what we're saying is right? I come at it a little differently than that. But let me give the standard story psychologists tell, is that judges tend not to believe them. So a good example is all of the science on eyewitness identification. There's very good evidence that many examples of eyewitness identification where someone witnesses a crime and then has to pick someone out of a lineup later on and identify that person as the perpetrator is very unreliable. Indeed, in the United States, we know at this point that a very high number of false imprisonments cases arise from bad eyewitness identification. Psychologists have believed this for maybe 40 years. And it's really only in the last 10 to 15 in the United States that judges have come to believe that. And that's a real gap, that there's a bit of science out there that's very hard to get into the courtroom. I think most scientists would say the same thing, that judges tend not to believe them, that it's partly how science ends up in the courtroom. It's often done in an adversarial setting, so there are two sides. Often there's a motivational problem that, believing that eyewitnesses are wrong makes it harder to convict a criminal defendant, and, judges are, big believers in law and order. And so there are impediments to getting judges to believe science. There's no doubt that that's true. I don't know that I have anything to speak to about that. I did do a few studies in which I varied the identity of the scientist testifying as male or female, see whether judges would believe a male scientist more than a female scientist. A little, it turns out to be the answer. But judges are generally skeptical of the way science comes into the courtroom. For me, when I think about this as a psychologist, I think many of the scientific findings from criminology and psychology really don't necessarily belong in the courtroom. They belong in front of legislators. So if we believe that eyewitnesses are unreliable, the better reform is perhaps not to present an expert witness to a judge to tell him or her that eyewitnesses are unreliable, but it's to adopt a set of rules governing how eyewitness identification gets undertaken. Because the psychologists who study it have better and worse ways of engaging in eyewitness identification. And ideally, the police and criminal investigators adopt the more reliable techniques. And if they don't, then legislatures force them to do so. So that the remedy may be not one case at a time. And judges are very ill-suited to judging science. It's not something they're particularly going to be good at one way or another. Whether that science is epidemiology, criminology, neurology, or the like, it's not something they're trained to do very well. And there are many programs in the United States for training judges to be a little better about science, and they don't really work that well. Honestly, if one believes something different about a system because of something criminologists have learned, the reform might be a systemic reform more so than a judicial reform. I know it's probably not a very good answer, because I sense that you're seeking a sort of magic bullet for how to convince judges that science is right, and I certainly don't have one. I do know that judges believe science when it's more congenial to their beliefs about the world. That is a bit of evidence. We do have some evidence on that. That if a judge who is more inclined towards certain sort of liberal democratic values is more likely to believe an expert on eyewitness identification, is more likely to believe an expert on climate change too, and more likely to believe that certain neurological syndromes are at the root of certain criminal activity, right? So if the science is sympathetic to the judge's politics, as it were, then they're more likely to believe it. That's not a cure for the system, of course. It just means some judges are going to believe things and others are not. But to me, that suggests that the reform is really in a sense political and belongs more in front of the legislature.
Muy bien. Creo que acá tenemos una.
Thanks. In your paper, you identify the use of simple strategies as the gambler's fallacy. as a present element in decision making, specifically in cases of asylum seekers, exposed by Chen in the paper. So which strategies could be used for neutralizing or making visible these justice problems or injustice problems that arise from this type of strategies with asylum seekers cases?
Could you repeat the first part of your question again? I missed the phenomenon.
The gambler's fallacy.
Oh,
when
the
you talk
gambler's
about the
fallacy.
gambler's fallacy.
Oh, the remedy for the gambler's fallacy. Oh, goodness. So let me-
Especially addressing asylum seekers, which I
Oh,
think
yes,
is
okay.
something she's very interested
Right, that's in the paper. So let me make sure the audience knows this. The gambler's fallacy is a simple one. If you're betting on a coin flip, if you flip a coin, say you win if it's heads and you lose if it's tails. And you repeat this. If the coin comes up heads, you win, great. If the coin comes up heads again, great, you win. You feel like tails is due, that the next one is more likely to be tails if the first two were heads. Right? So even though the coin is a random process, if you admit and believe it's a fair coin, people will tend to think that if you get the same thing a couple of times in a row, then the other one should come up differently. There's a really clever study done by an economist named Daniel Chen on asylum applications in the United States. The cases, judges hear many cases in a row of whether to grant asylum or not in the United States. And there's a tendency to not do the same thing 3 or 4 times in a row. So if a judge grants asylum twice, then in the next case, she's more likely to deny it. If she denies asylum twice, she's then more likely to grant it. Now, the cases are independent from each other. They have nothing to do with each other. They're just 3 or 4 different cases in a row, but having granted it twice, then it seems like it's time to deny one. Or having denied it twice, well, next person's going to get lucky, and they're going to grant it. That actually speaks to a broader problem in the U.S. asylum system. The United States system of granting or denying asylum is, I think at the moment, best described as entirely a System 1 process. There is virtually no law to the whole thing. There's a really terrific study done about 5 years ago, but it turns out it's still true, that the rate at which our immigration judges in the United States grant asylum varies between 5% and 95%. So any one judge might only be granting 1 in 20 applications. Another one might be 19 out of 20. And the standard itself looks very law-like. It looks very principled. It looks very System 2. If the applicant has a good faith belief that they will be persecuted in their home country, they're entitled to asylum. There are some wrinkles to it, but it essentially is that. That looks very law-like. But it's entirely at the discretion of the judges. Immigration in the United States is a deeply political topic at the moment, of course. And it means that some of the judges, in fact, bring deep political beliefs to that, and they're running unchecked because our system is essentially overwhelmed. We have way too many cases for the number of judges we have. It's actually been noted that rather than build a wall, the president ought to hire 1,000 immigration judges. Because the backlog of cases is now 3 years. This is a terrible thing. Our immigration courts were shut down while the government was shut down. A part of our government was shut down for a month and a half for no obvious reason. And the immigration courts were part of what was shut. Anyone who had a case pending during those 3 months was rescheduled to 3 years later. They didn't just back everything up. They put that off for another 3 years. So if you had a case pending, you get to stay in the United States for 3 more years. Or if you had a deportation order that you were trying to lift, sorry, you're going to get deported. Our system is just truly broken at the moment. So what we need is more judges, because to get to System 2 thinking, you have to slow down. The judges right now have to prosecute so many cases that all they rely on is their motivation. What do they think of the immigration system? So for some judges, what really would constitute a good faith belief that the applicant will be persecuted shouldn't count, right? So, for example, if they may be the victim of domestic violence if they're returned to their home country, for many judges will tell you they don't believe that's a good faith belief of persecution. Others think, no, of course that's what we're referring to. And there's not enough case law to tell them what to do so that they're allowed to instantiate their own political beliefs, and they don't have much time to think through what the law is, even if they knew what it was. So it is just entirely a System 1 process at the moment. So and that wasn't really an answer to the gambler's fallacy. It was pointing out that our system is so badly broken that I wish that were our problem right now. But that's actually a very hard one to fix. And there are actually a few different studies of sentencing now that show more or less the equivalent, that if you give out a couple of lenient sentences, a judge will then mete out a harsh sentence to someone. Right? It's like they have a certain budget for sentences that they've got to give out that day. And the only thing that can cure that is having a very regimented system of sentencing or asylum where there's some actual law that the judges can apply and that they can use checklists and scripts. And it might help here to have a little education on the gambler's fallacy. People can be convinced that that's a fallacy. It does take a little work. Right, that it's actually, when I was in practice, I used to win money from lawyers betting on the gambler's fallacy. There's a few ways you can set up games with people that they'll bet on the coin coming up tails more so than they should, and you can win money from people that way, and it can be really sort of ridiculous. It's a good way of de-biasing them, showing them how foolish that they're being. The coin has no memory. The cases are unrelated. But it's the least of our problems right now. That is a System 1 process. I'm not surprised that finding came out that way. I usually don't say that about social science because judges actually surprise me a lot. But that one I'm not that surprised by because as soon as I read the title to that study, I was like, oh, that worked. That was a good one to run. And because the system is right now so fraught, there's just not enough appellate work being done so that we have some law to guide our immigration judges, and the judges themselves are so overwhelmed with cases that all they can do is just process quickly.
I will make a very quick last question, I think. ¿Hay alguien más que quiera hacer una última pregunta? Bueno, there are two questions, and I wanted to make a last one. We're a little bit over the time. Is that
I'm
okay
sorry.
with you?
Yeah, it's okay with me.
Yeah?
I'll
Okay.
talk all day. I'm sorry.
Ok, entonces si quieren, juntamos las dos, nos dicen una y después la otra para que las pueda juntar también nuestro ponente.
Hola, buenas tardes. Mi pregunta va en relación a estas investigaciones y estos sesgos. ¿Hay algunos datos de en dónde quedan la parte de los valores de los jueces o del sistema y la parte de la dignidad humana en la toma y en la presencia de estos sesgos cuando toman decisiones? Gracias.
So we're going to put the other question together to see if you can.
Yeah, okay. It might be very different.
Hello. So my question is more leading to the aftermath of your research. Obviously, your research purpose is to make obvious that their decision making is based on bias and stereotypes. But once you let the participants know how they did these questions, do you do some kind of follow-up in order to measure if this research has an impact on their life and on the way they make their job?
Good. Those are two distinct questions, so but I'll answer both. So I'll do the second one first because we have just started in the last 2 years collecting more data on whether we're actually doing any good. So do judges who listen to our lecture make better decisions? The tentative answer is a little. And it's not that surprising. I mean, we basically have an hour to 2 hours with judges typically. We do get them involved in the research. They are completing these hypotheticals so that they're somewhat invested in the outcomes. If we test them later in the same day, we find they do a little better, just a little bit. Unfortunately, I actually have some data that suggests if we let them deliberate in groups, they actually get worse again. So it's like they talk themselves out of the learning that they got from us. We were hoping it would go the other way, but we are working on that. It does look like we do a little bit of good. As I said earlier, that a lot of the remedies are very specific to specific domains, so it's hard to teach generally to the judges. But a few judges, a few problems at a time. The other question is a good one too. That we do know a little bit about how, well, actually, we know a lot about how judicial values affect judicial decision making. The most common thing that social scientists in the United States study in judges is how political attitudes affect judicial decision making. You asked a little bit more specific about how judges react to human dignity. I don't quite know that, but I do know that judges' political orientations do influence their decision making. That's bad news, because judges are supposed to be neutral, and yet they rely on their attitudes about the world, so that judges who are more authoritarian in law and order are less respectful of the dignity of litigants in front of them. We know that's true. Fortunately, we know that it's less true for trial judges than it is for appellate judges. Now, why is that? Well, appellate judges, in fact, have more freedom and discretion to implement their political attitudes than trial judges do. Trial judges are supposed to follow precedent. They're supposed to follow authority from above, and the rules, by and large, tend to be more neutral. Appellate judges are a little free to change the law a little bit, and that's a source of mischief from our perspective. The trial judges do rely on their attitudes, but the effects are much smaller. So in the United States, for example, we've done a fair amount on sentencing decisions among judges, and we ask about their political attitudes. And they do influence the sentences, but it's a very small effect. It's something like 1/5 of a standard deviation. Like if you take the most extreme Democrat and the most extreme Republican, they differ by a couple of months in an average sentence, not a couple of years. So it's not a big effect. Judges at the trial level, fortunately, are mostly motivated by the person in front of them. They see a human being generally. They don't always empathize in the way that we might like. And the empathy that they express certainly does vary based on the demographics of the person in front of them and the judge. But there's a fair amount of empathy there. We do, in fact, over and over see studies where there's legislation maybe to make a sentence more extreme or more tough, and judges often ignore it. Judges tend to be more lenient than legislatures because they see a human being in front of them, by and large. So it does vary by judge. We do know their values matter, but it doesn't matter as much as you'd think. It matters more in the appellate court, and certainly in the United States, the Supreme Court is almost wholly a political values-oriented court. But at the lower court, it's very much the trial judges judging a human being, and that's pretty good news.
Okay, so a very, very last question. How does social change and new social narratives can influence cognitive biases? So we want to be optimistic here, because in Mexico we're just starting to work with cognitive bias towards different groups. And the idea would be in the States, for example, discussions regarding race have been there for many years, many decades. And as you said in your presentations, many judges are quite aware of this, and they try to be very careful when they address racial issues.
Yeah, the script I know about, and actually relates back a little to the scientific data. Judges believe, in the United States, judges believe the criminology data on sentencing disparities by race. I don't get a lot of skepticism about that. A few questions here and there. They might ask whether it's justified because of differences in crime rates or this or that. But by and large, they don't really attack the numbers, which I think gets at your script a little bit. So that's why judges in the United States think that if I give them the name of a litigant and it's something that's stereotypically African American, like Deshaun Jackson, which is not a name many European descendants are going to have in the U.S. That's very much an African American name. If I give them that name and a sentencing decision, it triggers everything they know about criminal sentencing. And they know there are disparities, and they're not happy about it. Right? So it requires two things. First, they do have a motivation. Judges in the U.S., with very few exceptions, embrace the idea the system ought to be egalitarian. That was not always true. If you look at some cases, even published opinions from the 1950s and 60s, they're rather horrific what judges were willing to write about defendants in front of them. Right now, if a judge uses a racial epithet in front of a defendant, he's apt to be disciplined, possibly even removed from the bench. Whereas in 1960, this was commonplace, right? So we've had a big change in the United States. Now, are the judges still biased? Yeah, they still harbor the invidious biases, but they know they're not supposed to express them. They believe they're not supposed to express them, and they believe it's wrong that there's a system that produces that disparity. With those three things, I can then run sentencing studies and not see a difference between the judges, because it's triggered, and there's pretty good social psychology on that when people are motivated to treat people alike and are aware that they might be biased and are triggered that this might be a situation in which they're biased, they can overcome the bias and use system 2 and think about the person differently other than their racial or ethnic category. So I would, what would I encourage? More information in judges. I mean, and judges, you know, a system that produces judges that believe that in a system of egalitarian judging, and informing them as to what the system actually does produce. That seems to work in the United States.
Well, thank you very much to Professor Rachlinski. Let's give him an applause. And, el día de mañana tenemos un taller, algunos de ustedes también están inscritos para ese taller, va a ser un taller un poco más metodológico. Les pedimos por favor que estén aquí a las 10 en punto de la mañana para que podamos empezar a tiempo y terminar a tiempo. Y bueno, y también aquellos que están siguiendo el ciclo, nuestra próxima sesión sería el 4 de junio para hablar sobre cuestiones de justicia, inclusión financiera, y después nos vamos hasta el 21 de agosto también para ver cuestiones de justicia desde el ámbito neurológico y la empatía. Entonces, ojalá que nos puedan acompañar. Les agradecemos mucho el haber estado el día de hoy. Creo que fue una sesión muy enriquecedora y bueno, tuvimos un excelente ponente. Así que,
gracias.
Thank you very much, Jeffrey.
Muchas gracias.
Thank you so much for that.
It was fun.
Oh, that's good. Tomorrow